So dear students, let us start the discussion today on the second ARC report number 2. So I am giving the code ARC 4th report, the subtopic second, and we are doing the first video on the subtopic second. The name of the subtopic is Ethics and Politics. So I prepared a small ready reckoner with regard to this topic. So the topic starts with ethics and politics. So the major issues that have been covered are the criminalization of politics, electoral reforms till date, coalition politics, and development of an ethical framework for the coalition politics. With regard to the disqualification of the members, there is a wide coverage in this particular article. Now, first topic, let us see the criminalization of politics. Here, ethical framework for governance, it has to start from the politics. So in any democracy, the governance of the country is more dictated by the values in the politics. In India, the major challenge today is about the criminalization of the politics. It can be described as the entry of the criminals into the electoral process and taking the seats of representatives. How it is starting? The major reason is the failure of the criminal justice delivery system. In those circumstances, a people's craveness or else people need for the speedy justice is providing them or making them the welcome characters in the society in the short run. But in the long run, it is leading to lawlessness. On the other side, these criminal elements want to make the system an ally rather than an adversary. And their need is motivating them to enter into the politics. A police who is generally an adversary will become a friend for the politicians when they enter into the politics. So it is in the short term a win-win situation, but in the long run it is dampening or weakening the governance of the country. So what we have to do to control this, and what are the changes that have been brought in? And the second major thing which is affecting the country is related to electoral expenditure. So increase in electoral expenditure is the root cause for the shift in the policies and also vicious cycle of corruption to erupt in the country. Now, in these circumstances, what are the recent changes that have brought in with regard to the reduction in the election expenditure and also criminalization of politics? The recent changes, the first one is the 91st Amendment Act. We all know that any person who is disqualified is not allowed to take any ministerial position or chairman of a corporation or a board unless he is re-elected. So the 91st Amendment Act is a clean development. And updation of the electoral rolls, providing of electronic voting machines, and a fair revision process of the electoral rolls and voter ID cards, issuance of voter ID cards, disclosure of the antecedents, the criminal antecedents of the candidates and Supreme Court judgment, disqualifications of the persons convicted of the criminal offences, code of conduct. All these are the changes that have occurred recently. So in this case, the most important aspect that is related to is the state funding of elections. So if you take about state funding of elections, there are three major patterns. One is a minimalist pattern, maximalist pattern, and mixed pattern. So in a minimalist pattern, the state will provide for a minor chunk of the expenditure related to the elections. Beyond elections, the management of the political party is purely the responsibility of the party holders. In a maximalist pattern, the maintenance of the political party and also a provision of the state election expenditure is the responsibility of the state. In mixed expenditure pattern, the state will partially reimburse the public funding on a matching grant basis. It means something if the party collects or accumulates for itself, the state will provide for a matching grant to the level the state has accumulated that, the party has accumulated that. So this is called as a mixed pattern. In India, in 1965, if I am not wrong, the corporates funding the elections was abandoned. Later, by amending the companies law, this again brought into the picture. Now, with the existing situation, corporates can provide for the funds to the political parties. So, in this case, there are three important committees. One is Dinesh Goswami Committee. Next is Indrajit Gupta Committee. So, they have recommended for a limited support in the elections in the form of kind, it means publicity material, all India radio airtime, like this in the form of kind, a providing of electoral rolls can be taken up. The second ARC also in line with these people, it has recommended for this partial funding by the states. Now there is important law that is called Election and Other Related Laws Amendment Act 2003. It was actually based on the Manmohan Singh Committee report. So what it says is, any corporate company or individual donating to the political parties is exempted from the tax. Now, either it is a third party expenditure or expenditure by the political parties or by the candidate that comes under the expenditure ceiling prescribed by the Election Commission. Any amount greater than 20,000 rupees received by a political party, it has to disclose that in the public domain. Now, indirect public funding to the candidates of recognized political parties, not to the independents. It means this law, what it has prescribed for is a partial funding of the elections to the candidates of recognized political parties. Similarly, airtime sharing equitably by all the political parties, that is recognized political parties. But however, that has to be decided between the union government and election commission in consultation with each other. So this is what is Election and Other Related Laws Amendment Act has talked about. Recently, it has come to the notice that most of the political parties are giving only a partial disclosure of the amounts greater than 20,000 which was given as contribution to them. And next is the disqualification of the members. So, the criminal charges, the people who are facing the grave criminal charges, as of now, either it is corruption or any other grave criminal charges, if they are convicted in a court of law, they are disqualified to be the members, unless they are evicted of these charges in the higher court. Now, second ARC goes to an extent saying that it has to be a total disqualification because there are two reasons over here. The criminal justice delivery system is very slow in India, and people's right to representation, that is fair representation, has to dominate over the candidate's right to contest. In this context, any person who is facing the grave criminal charges such as murder, rape, war against the nation, these people, they have to be disqualified to contest the elections, even they are being convicted, before they are being convicted. So here there is a chance that this provision can be misused. So only judicial magistrate after initial inquiry has to admit the charges. That's what is given a safeguard recommended by second ARC. Now, the political defections is another major challenge. So you have anti-defection law is in place. But under the anti-defection law, the speaker is the authority who decides about the disqualification of these defections. So many a times parochial behavior is observed. If you can see recently what happened in Arunachal Pradesh, you can talk about the misuse of the anti-defection law or anything else. It's become controversial. So in this context, the disqualification under anti-defection law, the authority shall be president or governor of the state in consultation with election commission. And along with this, there has to be an internal democracy in the political parties. So internal election into political parties to elect their respective leaders has to be encouraged. Next is Article 102. It also talks about the disqualification of the members. Under 102E, so Parliament can make any law to disqualify the members. So under this, an exhaustive conditions of disqualification shall be prescribed to the MPs. Similarly, state legislature can make a law under Article 198 subclause E. So, Union Parliament and state legislature shall make an exhaustive disqualification law. Now, publication of accounts by political parties. In Subhash Chandra Agarwal case, if you see recently, the Central Information Commission said that all the political parties shall disclose their finances to the people and they shall come in the ambit of the RTI. In line with this, the second ARC's recommendation is also like this. Political parties have a responsibility to maintain proper accounts and get them audited. And these audited reports have to be kept in public domain regularly. And then, appointment of election commissioners. So already this has become a controversial with regard to Gopalaswamy Iyengar when he was the chief election commissioner and Naveen Chawla was the election commissioner. The accusation was that Naveen Chawla was working in favor of certain political parties. So in this context, what the second ARC says is, any appointment of CEC and election commissioners, it has to be by a collegium headed by the Prime Minister, in which Minister of Law, Leader of Opposition, and Deputy Chairman of Rajya Sabha, Speaker of Lok Sabha shall be the members. So a collegial appointment of the Chief Election Commissioner and other election commissioners was recommended by second ARC. And with regard to the election petitions, there is another issue. Now, high courts, they take the election petitions, high courts and Supreme Courts. Due to huge pending of cases, many times these election petitions are delayed. So in this context, what second ARC says is, let us constitute the special benches in this matter, so that a time-bound disposal of the election commissions can be possible. Now, coming to the coalition politics and ethics, you know that India has entered into a coalition era. So, we shall have a framework to deal with this coalition politics. So, majorly the coalition partners, they are losing or they are leaving the coalition in the midstream, making the coalition politics unstable. So, there has to be an ethical framework to control this. And here most of this is due to political opportunism or private interests. What the second ARC says is, before the elections explicitly, a common minimum program has to be suggested. Or after the elections, before the formation of the government, a common minimum program has to be prepared. Once the parties agreed to this, any party wants to leave in the midstream, it shall lead to the disqualification of the representatives belonging to the party, and they shall seek the fresh mandate from the people. So, here the second ARC is very, it's a very bold recommendation. And it also recommends the amendment of the constitution for this purpose. So, this is about this report. So, I will cover this part of the report in the next class for you. So, thank you very much. And let us see next thing where we have covered, what we have covered. Now, so this is what is the second chapter, that is ethical framework we have covered in this class. So ethics and politics I have covered. So the recent improvements I have discussed. Issues in political reforms. This is one thing which we have discussed. Next is, we have discussed about something called as issues in political reforms. Next, a tightening of anti-defection law, disqualifications, coalition and ethics politics, or coalition and the ethics with regard to these elections. These are the things which we have discussed now. So you can go through this particular report. And the second part I will discuss within a 2 or 3 days time. So thank you very much and hope you are enjoying these reports. And I will also give you a question on this report. Try to attempt that. Thank you very much. And one more thing I forgot. Whenever you read this report, always be careful, because the report is not useful in its isolation. For example, electoral reforms is a topic with regard to representation of People's Act. Electoral reform squarely falls over there. So it means this information you have to update in your Representation of People's Act in GS paper 2. Similarly, disqualification of the members, Article 102, you have to update your notes. So you have to use this information appropriate to your syllabus. Again, don't consider the report away from your syllabus. That is going to be very dangerous. Thank you very much. All the best.